Hello everyone, my name is Pratiksha and today we'll continue with module 3 in which we'll understand about legal writing and drafting and we'll understand the styles that every document require. Let's just get started with it. So be focused and read the materials that has been provided to you. So, legal writing and drafting are essential skills for any lawyer as ensure that legal documents are clear, precise, and enforceable. Unlike general writing, legal writing has a formal structure, specific terminology. It must adhere to the legal principle. Components of legal documents, legal memos. The legal memorandum is a document used to analyze legal issues and provide advice. It is commonly used in law firms, corporate legal departments, and courts. Let's understand the structure of legal memo. First is heading, includes the name of a writer, recipient, date, and subject. Second issue statement clearly states the legal issue being analyzed. Brief answer summarizes the conclusion concisely. Facts lays out the relevant facts of the cases. Discussion analysis applies legal principle to the facts, citing statutes and case laws. Conclusion provides a reasonable, reasoned answer to the legal question. Let's understand how the contracts are being drafted. A contract is a contract is a legally enforceable agreement between two or more parties. It outlines right, obligation, and remedies in case of breach. What are the essential elements of a contract? So first is title. It clearly identifies the type of contract, example, lease agreement, service agreement, preamble. It provides background information about the party and purpose. Definition clause defines important terms used in the contract to avoid ambiguity. Obligation of parties. It specifies what each party must do under the contract. So, yeah, we were on contract. So, contract is a legally enforceable agreement between two or more parties. It outlines rights, obligation, and remedies in case of a breach. So, what are the essential elements of contracts? Title, preamble, definition clause, obligation of parties, payment terms, termination clause. So, title clearly identifies a type of contract, example, lease agreement, service agreement. Preamble provides background information about the parties and purpose. Definition clause defines important terms used in the contract to avoid ambiguity. Obligation of party, it specifies what each party must do under the contract. Payment terms, details about payment structure, deadlines, and penalties. Termination clause specify conditions under which the contract may be ended. Dispute resolution clause indicates how disputes will be resolved. Example, arbitration litigation governing law determines which jurisdictions law apply to the contract. Signature signed by the authorized representatives of the parties involved. Example of a simple contract clause is confidentiality clause. The parties agree that any confidential information shared under this contract shall not be disclosed to third parties without prior written consent. Let's talk about pleadings. So, pleadings are formal written documents filed with the court by parties in a lawsuit. They set out claims, defenses, and legal arguments. The types of pleadings can be plaint, civil suit. So, it's a document filed by the plaintiff outlining grievances and seeking relief. Second is written statement, defense response. The defendant responds to the plaintiff's claim, affidavit, a sworn statements of facts submitted to the court. Petition, a formal request to the court for a specific legal action. Application or motion, request for interim relief or procedural orders from the court. Moving on to writing style. So we'll understand here in this subtopic writing style. We'll understand about the clarity, consciousness, and structure. Clarity in legal writing. Use simple language to ensure the reader understand the legal document. Avoid ambiguity by defining key terms. Use short sentences to express ideas clearly. For example, instead of the party of the first part shall undertake to perform the obligation as agreed upon in the said agreement, right? Party A agrees to fulfill the obligation under this contract. Conciseness in a legal writing. Remove unnecessary words and redundant phrases. Use active voice for directness. Avoid legalese, complicated legal jargon. Example, instead of writing the aforementioned contract, which was executed on the date of March 1, 2024, by and between the parties, write the contract signed on March 1, 2024, by both parties. So, what should be the structure in legal writing? Let's understand this. Structure in legal writing organize information logically with headings and subheadings. Use numbered list of bullet points to break down complex points. Maintain parallel sentence structure. Example, the contract includes terms on payments obligation and dispute resolution. What should be the practical tips for teaching legal drafting? So, we can have interactive exercises. Um, so draft a short legal memo, contract clauses, or a pleading. It will help you understand how to draft it and what style do you should adopt, and it will also develop your researching skills. You also can take the case studies. Um, you can also do a peer review, like you can exchange drafts and suggest improvements to your mate. We can also like conduct a contract negotiation exercise where you can have a kind of mock negotiation. We can also in your friend circle do one thing. We can you do comparison activity. That is like whoever have like not written so well, you can take the example of it and identify mistakes that has been committed in that, so that the other person who has committed the mistake will understand this should not be the things that he should repeat. So, legal writing and drafting require precision, logical structure, and a clear, concise style. By mastering these skills, you will be able to draft effective legal documents that serve your intended purpose in practice. Moving on to developing legal arguments and analysis. So, legal arguments are the backbone of the advocacy and legal reasoning. Of course, everyone knows about it. A well structured legal argument must be logical, based on sound reasoning, well supported, citing laws, precedents, and legal principles. It should be persuasive, presented, convince, convincingly to support a legal opposition. Understanding how to develop strong legal argument help lawyers in court cases, negotiation, and drafting legal documents such as pleadings, contracts, and opinions. Developing legal arguments and analysis. So, a legal argument is built upon rules, facts, and reasoning. It follows a structured approach. Use IREC method, issue, rule, application, conclusion. Here, issue means identify the legal question at hand. Rule state the relevant legal principle. Application apply the law to the specific facts of the case. Conclusion reach a well reasoned conclusion. For example, let's understand the IRAC in action. Scenario: a tenant has not paid rent for 3 months. The landlord wants to evict them under the Transfer of Property Act 1882. Here, issue is, can the landlord legally evict the tenant for non payment of rent? Rule is, under Section 106 of the Transfer of Property Act, a landlord can issue a notice for eviction due to non payment of rent. Application says the tenant has not paid rent for 3 months. The landlord can serve eviction notice. Conclusion: the landlord has a valid ground for eviction. What are the types of legal arguments? Arguments based on statutory law derived from acts, statutes, and regulations. Example: arguing that a contract is void under Section 23 of the Indian Contract Act because it has an unlawful object. Argument based on case law, that is precedent, refers to judicial decisions that set a precedent. For example, using the Keshwan and Bharti case to argue that the basic structure of the constitution cannot be amended. Argument based on legal principle, general legal doctrines like equity, natural justice, and good faith. For example, invoking promissory estoppel in a contract dispute. Argument based on policy and public interest, used in cases where no clear statutes applies, relying on social justice, economic impact, or fairness. For example, advocating for privacy rights in the digital age using Puttaswamy case. Moving on to how can you strengthen your legal arguments. So always use strong legal evidence. So always use strong legal evidence, cite statutory provision and relevant judgment, address counter arguments, refute opposing points logically, follow a logical flow, so ensure clarity and coherence. Next is use persuasive language, frame arguments persuasively. How do you draft a legal opinions and memos? Let's understand that. A legal opinion is a formal document advising clients on legal matters. It is usually written by a lawyer for a client or another lawyer. Structure of a legal opinion is: first is introduction, outline the purpose of the opinion. Next is fact, summarizes the facts of the case. Next is legal issues, identifies the legal question involved. Analysis. Next is analysis, applies relevant laws and precedent to the facts. Conclusion, provides a definite legal answer and recommendation. For example, uh, you can write a legal opinion, first write to, then whom you are sending from, date, and then the subject. Now comes the introduction part where you have to sort advice on whether you can legally evict a tenant for non-payment of rent under Indian contract law. Next is the fact. The tenant has failed to pay rent for 3 consecutive months despite multiple reminders. Legal issues, whether the landlord has a legal right to evict the tenant. Next is the procedure to be followed for eviction. Legal analysis. Under Section 106 of the Transfer of Property Act, a landlord can terminate a lease by giving a 15-day notice. Case law can be taken, let's say XYZ versus ABC 2019 confirms that continuous non-payment is a valid ground for eviction. Now you can conclude. You may proceed with eviction by serving a formal notice under Section 106 of Transfer Property Act 1882. If the tenant does not vacate, a civil suit may be filed. Let's understand about the legal memos. So, a legal memorandum is an internal document used in law firms or organization to analyze legal issue for advising a client or making a legal decision. Structure of a legal memo is first you write heading. Heading is the states the recipient, author, date, and subject. Statement of facts outlines relevant facts. Issues defines the legal questions. Brief answer provides a concise summary of the conclusion. Discussion analyzes the issue in detail using statutes and case laws. Then conclusion provides a final legal opinion. Example of legal memo is you start with to the senior associate and then write your name from and then date and then comes the subject liability of employer for workplace injury. Now you write the statement of facts. An employee at XYZ Limited suffered an injury while using defective machinery at work. So issue is here. Next is issue. How do you write it? Is XYZ Limited liable for damages under the Employee Compensation Act 1923? So, and in the next following para, you write about brief answer. So, yes, XYZ Limited may be liable under Section 3 of the Employees Compensation Act, which mandates compensation for workplace injuries caused during employment. And then you discuss about the legal rule. Let's say section 3 states that an employer must compensate an employee for injuries arising in the course of employment. And about the case laws, ABC Limited versus DEF 2018, where the employer was held liable for injuries due to defective machinery. Now, application, since the injury was caused by machinery provided by XYZ Limited, they may be held liable. Conclusion, XYZ Limited should compensate the employee under Section 3 of the Employees Compensation Act 1923 to avoid litigation risk. Next is a practical exercise for you guys. Legal analysis exercise. So in this, take a case scenario and apply the IREC method. Draft a legal opinion, assign a legal issue, and so I'm assigning a legal issue, or you can yourself take a legal issue and write a legal opinion on it. Next is memo writing challenge. Draft a memo for hypothetical legal case. Next is mock legal arguments. Conduct so you can in your mates conduct a debate where you will argue a case using legal reasoning. These are the practical exercises that you can do for the improvement. Next is the I'll conclude it with explaining you that developing legal arguments requires logical reasoning, legal research, and persuasive writing. Legal opinions and memos serve as advisory document that must be clear, concise, and well structured. Mastering these skills is essential for any aspiring law. So remember these key points and practice more and more. You will learn it so well.